For Gator TeamChild, which is a juvenile law clinic at the University of Florida, Levin College of Law. What I do is I work with third-year law students in our clinic, and they have almost like a fellowship like you would see at a doctor's office, where the students work with me directly in representing kids in the dependency system, the delinquency system, and other special areas where kids need attorneys. I'm presenting today with Jessica Zissimopulos. You want to introduce yourself a little bit?
Good afternoon. My name is Jessica Zissimopulos, and I am a juvenile attorney. I'm a former CLS attorney as well as juvenile prosecutor, and then I've gone into private practice and now work on the defense side with children and also with families in dependency court.
Along with being a law professor, I'm also a photographer, and I started to look into sharenting as an issue that affected me as a mom and as a photographer. I was curious how we could continue to share information about ourselves and about our kids while also protecting their digital footprints. Ever since taking on the law clinic and working through the university, I've really become very interested in children's rights from the perspective of a child and how the child might feel about certain things that we do as adults that can impair their ability to fully exercise their rights as they get older. And so I started to question whether kids have a right to privacy and whether caregivers have a right to share. At the time that I started to question this, I was a writer for the Washington Post, and on their parenting blog, I would often write about my own kids' experiences that they were having. And I realized that my kids were having digital footprints that were created long before they had the ability to even take their first official step on social media or online in any way. And so what I wanted to explore is how do we balance these rights? What rights do kids have and what rights do parents have? Anyone in this room have experience where they've seen on social media someone in their family, someone that they knew, or maybe someone that they knew through one of their cases share about a child in a way that made them question whether or not that adult had the right to do that? Yes. Let's go around. I'd love to hear some of those experiences that you've had. I think we had a hand back here, a hand back here. Does anyone want to share? Sure. If you're willing to share.
Mine was in a juvenile justice system, and a case manager was very happy about the result of the delinquency proceeding and probably shared some details that were inappropriate.
Got it. Yep. We see that a lot. The excitement of the adult might impinge on the child's right. Who else is willing to share what they saw, whether it's through their cases or through their personal lives?
Close to the same thing. A child that was in foster care, the parents were going to adopt. They attended a social function, and there were a lot of people focused on the kids, and so people unrelated to them posted the pictures on Facebook.
On Facebook, got it. Yeah.
I'm careful about what I post on social media to try to be, I try to put an image, I work with a professional image, and sometimes family members get a little over-eager of what they want to share in personal lives, so they tag me in things that I would prefer not to be tagged in.
So you've seen it from the perspective of being the person that was shared about in a way that you might not have wanted to be shared about.
And it kind of tarnishes a professional reputation that you're trying to cultivate.
Absolutely, yep. It changes what it might be that you're trying to put out there. Right in front here?
Yes, I had a TPR case where after the TPR, the biological parents traced the child who was being posted on Facebook and actually interfered, and we actually went to another court hearing to prevent that and to set some guidelines for the adoptive parents.
Great. I've seen very few cases make it to the appellate level that get reported that deal with this, but I have a feeling it's happening on the trial court level quite a bit. So, yeah. Yes. So sometimes it can be very helpful in our line of work. So when I started researching sharenting, one of the things that intrigued me, kind of left me conflicted, was the benefits that come when we go online and share our stories. In my life, this was playing out because the way that I did, a lot of the photography that I did was free pictures for kids at our local hospital at Shands who were going through chemotherapy, who were born with congenital abnormalities, kids that were suffering in the NICU, and by taking their pictures and then with the family's blessings, by sharing the pictures, we were doing a lot to raise awareness of the situations that these kids were facing, raising money for cancer awareness. There was a huge push by Humans of New York to get more funding for pediatric oncology by sharing stories of kids with cancer. And so I was seeing how these families were benefiting from sharing their stories online. Yet I also wondered how these kids might feel to one day go onto social media or go online one day as an adult and see that their medical information had been shared. For example, these two kids over here on the side, their pictures are being shared with their AOK. They're two good, they're friends of mine, their families are friends of mine, and they really gave, their families gave some moving testimony to how important it is for more funding for cancer research, and they were featured in the Huffington Post and many other big news outlets. But I can't help but wonder how they might feel to see that pictures like this might be out there long into their future as adults, and how it might affect them in the future, even with getting insurance or things like that. And I was, the center of the problem because I was the person who had taken the pictures. And I really wanted to better understand this because it seemed like no one else had really explored it from a legal perspective. So there's the unique issues at the heart of sharing about children in foster care. We see many times that different foster care agencies will share pictures of kids on social media in hopes that the children will be able to get adopted. And there's a lot of great stuff that happens from that. I mean, you've seen pictures get shared of kids that might be on your caseload, and you might share it as well, and hopefully somebody will connect or match through it the information being shared through social media. But at some point, these kids might come to resent being placed on the internet for the purposes of adoption. And how we go about balancing their interest, the state's interest, it can be very difficult. And it almost becomes what might be best for them might not be what they want. So we might also have some of the conflicts that we see between like an attorney ad litem and a guardian ad litem position. I think that we need to think more about this, and I am bringing it to you all here because you are at the epicenter of helping to form the conversation. I don't come here saying I have the answer or we need to stop doing it, but I come here saying we need to talk about it and think about it. Who's thought about this before in this room? Yes? Go ahead. Oh, who was willing to share? Raise your hand. So a lot of people thought about it. Who's willing to share?
Is now online, and when they reach the age of majority, they will not have had that ability to decide how and when, what purposes, and how much is shared. So they're going to be an adult now with some of my friends, they share their kids' pictures daily. So that child's going to reach 18, and they'll have, a documented life history on the internet, and maybe they didn't want that. So I frequently, discuss that with my husband, my in-laws, my family about how and when my children's images are used. And then in regards to my case kids, I can't help but feel protective over them too.
Yeah.
But it's a struggle because I know foster families are enjoying the kids and they want to share them and include them in their family pictures on Facebook. And so, I don't know. I don't know.
Well, you are a perfect audience. I'm writing a book on this, so I'll explore it from every angle, and I'll make sure that you can get a copy of that. Yeah.
It's maybe a dumb question.
There's no such thing.
How long, how long do these pictures stay on the internet? Is there an assumption that they stay on there forever, or is there an end point? Because that's material in formulating the theory about this. And if there isn't an end point, is there a way that there can be a time limit put on it by law, and that after a certain amount of time, because it seems to me that some of the solutions have to be containing it in some way.
That's a great question, and we'll get to what the short answer is. There is no time limit and there is no law. The long answer is I have some ideas for how the law could change to deal with this issue. But great question. So it also comes in, did we have some other folks who wanted to share that's over here? Go ahead.
I just wanted to share that there is an adoption website out there. I don't know if it's run by the state, and it has pages and pages of children that are for adoption with their name. all their information is out there, as opposed to us doing it personally on a Facebook page. But it is out there on a website, and I know working with teenagers, they're not happy about it because they said, we feel like we're up for sale, and it's on the internet.
Absolutely. My 13-year-old was telling me how he would feel or how kids his age might react to it. And, it can be easily something that kids can be targeted for bullying. It could be things that people want to, dependency records are kept private for a reason. And when we put them out there, that's no longer kept private.
And I think the point was also brought up in a previous place that if the kids don't get adopted, how will they feel about going back and seeing that they were on all of these websites and still nobody adopted them? So it could also affect how they feel on that end.
Yeah. So the Normality Act is, I was a CLS attorney for a number of years before I became a law professor. And the Normality Act happened in that window after I had left CLS. So when I came back in first as a guardian ad litem volunteer and then into my position at the clinic, I was learning quickly about the Normality Act. And one of the ways that it impacts kids that are in care with regards to social media is that now foster parents are allowed to post pictures of kids on social media just as they might be posting pictures of their own children. There are some limitations, but generally speaking, it's part of caregiver decision making, and that supervisor agency approval is not required for it. So we're seeing some of the issues that I think we're playing out in our own lives, in our personal lives, play out in the cases that we have, that we're involved with. And as leaders in the dependency system, we are in a unique position not only to observe it happening, but perhaps to educate the caregivers that we see about some of the risks of online sharing. And while we might not be wanting to say do this or don't do this, I think that most caregivers, just like most parents, do want to do what's best for their kids. They just lack the understanding, the resources, and the education to make the most well-informed decisions. So it's another area that we can improve outcomes for kids through education. So when we think about what normal and normalcy might be for kids on social media, is we first have to decide what is normal when it comes to sharing on social media. We have to think about how we can better conceptualize normal to be able to share these best practice models, because if we don't know what is normal and what is best, it's really hard to educate caregivers on what they should be doing. And how can we best support our kids, both our kids at home, our grandkids, our nieces, our nephews, and also the kids in care, so that they can grow up to have a positive and a self-actualized digital footprint? And what does that even mean? So while most of my presentation today, I will interchange the word caregiver and parent, I think that what I am really getting at is a big picture issue that affects all kids, whether in care or not. And for kids who are in the state system, I think there's just this extra opportunity for us to be able to help protect their digital footprints, and a responsibility that we do so as well. So what we know is that 1/3 of all kids in the United States already have an online presence. 75% of parents with kids under 18 use social media regularly, and 98% of moms who use social media share pictures of their kids online. I am one of those parents. If you are my Facebook friend, you will know that my children's pictures are online. So it's not something that I am standing up here saying is wrong, but what I am saying, it's something that we need to think about, and we need to develop some better practice models for it. The reason why a lot of parents share online is because they feel that they get some positive benefits. When we share our stories, we often can relate to family and friends, we can form communities, we can connect, we can create networks for us to get advice when we might need to. We can also oftentimes get support if we're trying to raise our kids, balance jobs, do lots of different things, and family is far away. But a Michigan study showed that 56% of parents share potentially embarrassing information about their kids online. 51% provided information that could lead to the identification of their child at any given time. And that 27% of parents who share online share inappropriate pictures. While many of the parents that were surveyed say that they got meaningful benefits from from sharing online, few parents were able to say that the pictures they personally shared were harmful to their kids, whereas most parents were able to point to other parents and saying what other parents were doing was harmful. So there's this lack of insight that parents have, generally speaking, with regards to how they share. There have been a lot of bloggers who have talked about their experiences sharing online, and while there have been some folks with disabilities who have come out and said that they are glad that social media wasn't around when they were little because they would have hated if their parent was sharing about their ADD or their autism or whatever it was that they were going through when they were younger, there is an entire separate subgroup of parents who say, I am my child's only voice. But what you're saying is you're attempting to silence that voice, and that voice needs to be heard. So for a parent whose child might have autism, by sharing their child's experiences, while that child may grow up to resent that digital footprint or that information being out there, that parent is also gaining advice as a parent for kids with autism, raising awareness, creating connections, and perhaps providing roadmaps for other parents who might one day be similarly situated. All of this work and all of my reflections found its genesis in self-reflection. As a children's rights scholar, I wondered how all of this information that we were putting out in the digital sphere could affect our kids as we get older. There's a conflict inherent in sharenting that no legal scholars that I have been able to find have devoted a significant amount of time to really look at and to really explore. There's the conflict in that a caregiver has a right to control the upbringing of their child. In most cases, the parent has this right to decide how to discipline a child, how to feed a child, where to send a child to school. And those things are pretty clearly outlined through our case law. The United States Supreme Court, for example, makes it clear that parents can choose to send their child to private school, that parents can choose within bounds the way that they choose to discipline their child or feed their child. But there's clearly an interest that a child might have in controlling their digital footprint. When parents share, they're trying to seek support, maybe gain advice, but at the same time, that child's interest might outweigh what that parent's goal is with regards to sharing. It's such a unique context because it's a place where the caregiver acts as both the gatekeeper, the one keeping a child's information private, and as the person disclosing information. When we think about things like HIPAA or FERPA, we put the parent in the driver's seat role in deciding what to be shared. In the case of kids in foster care, we put the case management agency in the role of deciding whether or not to share the children's information online, perhaps for adoption purposes. But both the parent, the caregiver, the case management agency, and the child have interests here, and they both have interests in keeping the information private, but also in the information's disclosure. So here's some questions about sharing or oversharing that I want to get at. What do you guys think is oversharing in the general context? If a foster parent chose to share a picture, what would you think of as an overshared picture by a foster parent or by a parent? School information. Right, so school information could be oversharing. It could perhaps lead the child to being identified. So if there's a safety risk with the parents, that by sharing the information, it could create a problem that the child might not be safe in some regards. Also, if the foster parent chose to share the child's report card or grades, they might be sharing FERPA-protected information. You know, kids might have an interest in having no information, whether negative or positive, put out in the digital space. And when a foster parent does that, they make the choice to share it. Other thoughts of sharing versus oversharing, or the difficulty in finding the balance?
Just saying the child is a foster child is too much, in my opinion.
That's a great point. Yeah, that the child being just the status alone of the child being a foster child really might be too much to be shared. And you're right, and that's a great point. Have you seen foster parents single out that this is my foster child versus the regular child? There's a term called humble bragging that I've heard in the context of sharenting a lot. And I think that's exactly what that might be an example of. By saying, look at my foster child, what you're saying is, you might say, look at my beautiful foster child's artwork. You're trying to put the focus on your child's artwork, but really you're showing yourself out as someone who's taking care of a foster child. And so we see that in the context of general parenting, where someone might put a child in the middle of a beautiful kitchen and post a picture, and the focus is kind of on the kid, but it's really on this granite countertops or something like that in the kitchen.
Virtue signaling also.
Yes, expand on that a little more.
It's when you, it's like humble bragging,
Yeah.
but specifically with moral positions.
Yeah.
It's the specified term for humble bragging on
Yeah.
moral positions.
Right, so virtual signaling by I am somebody who takes in foster kids or who might have foster kids here. Great point. All right, the face is blurred out. When this picture was first shared, the face was not blurred out. Is this sharing or oversharing? Does it matter if it's the child, if this is a picture of of a biological parent's child or a foster child? So this was a picture that went viral on social media about 2 years ago after the holidays, right between Thanksgiving and Christmas, and lots of my friends thought this was an appropriate picture to share. They didn't know who the child was. This was a picture that had gone viral, but clearly there's a lot of reasons why this picture could be harmful to this particular child or to children in general. Would you all agree? When I did a reverse Google image search, I found that the image had been shared thousands and thousands of times in many different ways over the internet. Not only could an image like this end up in dangerous hands, but I can't help but wonder if the child will one day come to resent being the subject of such a public joke. It's really something that this picture could always exist. Back to your question, how long will a picture like this exist? We don't know what will happen with technology in the future. So while right now this picture might be of an anonymous child, 10 years from now, facial recognition might make it so that when this person is in high school and their name is searched in Google, that this is one of the pictures that come back because of the facial recognition possibilities.
So I think oversharing or sharing if you have to ask yourself, if this person ever runs for president, how will the news media pull this apart?
Mm-hmm.
And if you answer in a negative way whatsoever, then that's oversharing.
How do we get the people who aren't in this room to see that? Because I think everyone here in this room knows that this picture could end up on their social media feed, right? Does anyone disagree that something like this could end up on their social media feed? Simone, it wouldn't show up on yours, huh? It would, right? It would. One of the things that I noticed when I see memes like this is that it's a lot easier to poke fun or to make memes of people that you don't know. So the fact that this is an anonymous child, it's not my child, not my friend's child, not my friend's friend's child, it makes it a lot easier for people to reshare it without thinking of the humanity behind this picture, that this is a real child. We don't know if this picture was initially shared by a parent with the meme attached, or if it was shared by a parent to an audience of 200 friends, and then someone right-clicked the picture and created the meme later. My concern is also that the lessons that we're teaching the next generation of young people when we create memes about strangers, whether about kids or about adults, gives teaches the lesson that our images are not ours, and that it is okay to find images that we might think are funny and to make them funnier. A lot of kids in middle schools now, they're getting very well-versed in Photoshop. They know how to change the background, change the captions, and it might be funny when we do it with a Marvel character, but it's a different story when we find a picture online and create an anonymity with regards to the person who might actually be in the picture. So we know that a parent's social media data is traceable, foster parents is traceable as well, and we know that it contributes to our online reputations. New York University explored how generally shared personally identifiable information could pose a risk to children, and they were able to find that through voter registration materials, kids could often be identified by name, location, age, birthday, and religion. There's the risk of stranger danger, like the tangible risks of what could happen to people, kidnapping and things like that. But there's also concerns about how this information could affect a child's digital dossier or the unwanted surveillance that we all experience as adults when internet companies are able to collect information about us. Just like how you might have gone on and shopped for a pair of shoes, and the next thing you know, there's ads for shoes on your social media newsfeed. How we share about our kids can do similar things in creating digital dossiers that are available to private companies, to the government, to school systems later on as kids get older. These digital dossiers or mini profiles can be enhanced over the course of a child's lifetime. Because there are so few scholars exploring sharenting, and even fewer legal scholars exploring sharenting, I get asked for interviews all the time about this topic. And I get asked for interviews here in the States, but I'm also often sometimes the first to know of issues that we're seeing around the globe as well with regards to kids and privacy. Australia, for example, I found out that their e-safety commissioner, they reviewed tens of millions of photos in these pedophile image sharing sites. They're not there weren't images of kids doing illicit activities, but they were images that pedophiles found attractive for whatever reason. It could be pictures of kids at the pool, or kids at the beach, or kids doing everyday, whatever, anything. And it found that 50% of the images on these pedophile image sharing sites had originated on parents' blogs or social media sites. And so what was happening was there was an entire underground market to go ahead and collect and save pictures that were shared on blogs and on social media, and then these images were used by pedophiles. And 50% of the images that this one law enforcement group, the E-Safety Commissioner in Australia, found originated from these parent blogs. The law enforcement in Canada was concerned about morphed child pornography, which I found out about when I was contacted by the National Post, one of Canada's leading newspapers. And it led me to explore the issue of morphed child pornography in detail. And what that is when an image is taken, an innocent image of a child is taken, and the face of that child is morphed onto the body of a youthful-looking adult or a computer-generated image, and it's used to look like child pornography. And we see this happening with adults. You hear about celebrities who are in these sex scenes, and they never meant to be in sex scenes, and there was this digitally altered pictures, but it's happening with kids as well. And it's one of the areas where the law has not caught up with the technology. While under federal law, there's something called the PROTECT Act, which criminalizes child pornography that includes morphed child pornography, or at least so far the law has been upheld in federal courts to criminalize morphed child pornography. Many states have not updated their laws. For example, in Florida, a morphed child pornography image would not be considered child pornography, and it would be considered protected speech under the First Amendment. There was a third DCA case that looked at this and said, it's not that I don't think this image should be it's not that I don't think this image should be criminalized, but if Florida wants to criminalize it, they need to update their laws, and they haven't updated their laws yet. Last year, I presented on morphed child pornography at Emory Law School, and while I was there was a bill pending in the Florida House to go ahead and change the law so that morphed child pornography would be a crime. But the bill failed, and not because of a lack of votes, it just died in the process, and so it still has not been updated. And I think we can all agree that morphed child pornography can be not just as harmful, but very harmful to kids, because the harm of the circulation of the image could come back and affect them in many ways. We also see that parents are shaming their kids through social media. This is a child who had a sign that was put up that said, "Do not trust me, I will steal from you, I am a thief." And the parent made the child stand on the street with this sign and then posted it online. Unfortunately, there were almost as many people on social media defending an image like this as there were parents and individuals who said that this image was horrible and wrong. I don't know how many CLS folks there are in this room, but I can't imagine a shelter coming through based on something like this. But it's certainly something that is wrong, and that we really want to educate the public that is not the best way to possibly, discipline kids. A lot of social media sharing and oversharing and the issues like this, I would say, fall more under a public health issue than a legal issue. While there are some margins where the law might need to step in, for example, CLS might need to step in or the department needs to step in, most of the cases, I think, are parents who just have not yet appreciated the importance of a digital footprint. And so a lot of my work has been aimed not at necessarily making laws that would prohibit this, but creating public health campaigns that would educate parents against doing this. I think it was you in the back here might have made a comment that made me really think of this quote that has really stuck with me throughout my research. Jeffrey Stulman states that the expressive liberty of parents becomes despotic when the child is given no real opportunity to embrace other values and to believe other beliefs. This was also a picture that went viral on social media. It's a picture of a mom and two little girls with gags on their mouth, a little boy with a thumbs up sign, and a dad with a sign that said peace on earth. Clearly making some sort of a statement through this. They did it to be funny. It also went viral, but it really creates a legacy for these kids that they may no longer want to be a part of when they get older. Not only is it offensive for the general public. As children reach adulthood, we hope that kids will share similar values to our own, whether they're our own children, whether we are the department and we're trying to educate kids to make good decisions and to have empathy. But we can only assume that even in extreme examples of parents making online choices to share images that most of us would consider abhorrent, the parent would defend their decision to share, such as in this case where the parents and the photographer just insisted it was a joke. But kids who grow up as the subject of their parents' online disclosures will often have a Google search result that reflects the publicly shared identity of their caregiver. This data could remain in Google's search algorithm for years to come, and it can reveal itself in embarrassing ways over the course of a child's life. One of the articles that I wrote for the Washington Post looked at what lessons we're teaching our kids through the information that we share online. And in this article, I spoke about an example of a teenager who was caught having shared a picture of a friend in a bathing suit in an unflattering position. And at first, when the parent went to yell at that child, the child quickly fired back, "You never asked me before you posted X, Y, or Z picture about me online." And the mom had to step back and say, "You know what? You're right. All these years, I have been asking you to smile, telling you to pose for a picture, not showing you the picture first, posting it online, sometimes listening to you nag and yell that, or complain that you didn't like the picture, and I never stopped." This isn't me speaking, this is the example in this. What lessons are we teaching our kids when we don't slow down and teach them the lessons? And so it's really important that parents think about including their kids and asking their kids for consent before posting any pictures, because it teaches our teenagers that they too need to get consent before they post a picture of someone else online. And when we're sharing pictures of kids through this department, through the foster care system as well, there's also this increased obligation that we really act intentionally with what we share. It doesn't mean we stop sharing altogether. It means that we listen to their voice and we let them play a role in how it is that we're sharing. One of the things that I've really started to do with my kids is treat my social media account not as just my account, but as our family's account. So if there's a picture of a child, if my kids know that if they want to share something, they can share the picture, or they can ask me to share it. If I do share something, they have a role to play in how the picture or the information is captioned. And they also have a role to play in responding to people who say, great trophy, or, awesome job on your schoolwork. They actually sit down at the computer by age 7 or 8 when they're learning how to read and write, read the comment and comment back. Because our lessons that we're teaching and everything else in our lives, we try to model good behavior, and then the kids hopefully will take off doing the same thing, opening the door for someone else, eating a healthy meal, whatever it might be. But social media is one of the only places where we cut kids out completely until 13 or 14, where we give them their first Instagram account. And there's been no modeling of appropriate sharing or appropriate commenting or how to engage appropriately in our digital communities. So what we know is that kids are embarrassed by what's being shared about them online by parents. BBC did a study on this, and they found that kids by age 9 had strong reactions to parenting, and that by 12, these reactions got even stronger. Kids know that there's rules about what they can do and can't do online. They don't understand why there aren't rules about what we can do. And they expect that they want to see more rules to exist. There was a study of 249 parent-child pairs that showed that 3 times more children than parents thought there should be rules with regards to what parents shared. So when the parents and the kids were separated and the question was posed, do you think there should be rules about what you can and can't share? The parents said no. The kids were asked the same question about their parents, and 3 times more of them said yes. So as we kind of work through these things and figure out the best way for kids to be able to have a role in this, what are some of the rules that you've seen for yourselves, for your people that you've worked closely with regards to how to decide when to share? What are some of the perils that you think about growing up under the newsfeed?
I think it's not even what to share, but just understanding how you can lock down some of Facebook and some of the, how you can protect your privacy. I just find so many people don't know that.
Right.
And I think it should be taught in foster parent classes, all of this. And I know it's covered a little bit, but it probably needs a little more emphasis.
Absolutely, yeah. This could definitely be something that's covered through foster parent classes, just like we might cover other important parenting issues.
The other thought I had actually started from the gentleman in the back table. The children that we take care of who are full of trauma are, placed in some sort of social media by foster parents or relatives, but even on their own could put themselves out there on social media. So now this child is growing up saying things, pictures everywhere, and now applying for a job, or 20 years down the road can't get something because of something before that they did or said that they really maybe didn't know much about.
Right.
So we're really holding them accountable since the time they were born until whenever it is that, it's just sad that these kids are in this situation and there still isn't a way to protect them.
Right. That's a great point. And the information that they're sharing about themselves, they're lacking the guidance that they need in order to make smart parent sharing decisions. There's no step in their education process to get that information. It's not going on through the public school system. It was not going on in the homes they were removed for, most likely. How can we ensure that it's put into place in their later processes? Yes.
Goes back to the question back there, is that no matter whether it's one of our children that we support, us or our children, friends, you can post something out there, and you put something out there, we go and we check, we see it, we screenshot it. They may delete it 5 minutes after they posted it, but you don't know how many people would do a screenshot and keep that. I do that myself on some of the teens that I'm a guardian for. I'll check their Facebooks and I'll see things out there that whether they have a gun in their hand or a bunch of cash or drugs or whatever, I screenshot it right away. So I always have that. And I'm sure that goes on a lot everywhere. So even though they may delete it a few minutes later, it's always going to be out there somewhere.
Right. That's a good point. It doesn't delete just because we might think it might delete. It still exists in different ways.
So, and to answer your question about the rules that we instill, so something I do on social media is if I want to tag somebody in a location or at an event, I always turn to them and I say, is it okay if I tag you? Because a lot of people don't want people to know they're not home. It opens your liability for robbers coming to your home, or if you're on vacation or whatever it is. And 90% of the time, the people I'm with say fine, but there's been an occasion where people say, no, I don't want you to tag me in that photo or that location.
Right. And I think that just like we would expect, that is the courtesy that well-informed individuals use when they share about other adults online. We have to find a way to turn that language into how we talk to kids about it too. So it's a great point. I was asked to give this presentation at the family law section of my local bar association, and it was really interesting to talk to family lawyers and family law judges about how this plays out in child custody cases. Because while I haven't seen a lot of the cases like the one you mentioned where it happened in a dependency case, they are starting to make their way in child custody cases where one parent might try to get an injunction to prohibit the other parent from talking about their kids online. And what I've gleaned is that there's very little that courts can do to stop one parent from sharing about the other parent, about the child online, because of the strong First Amendment principles that we have here in the United States, that we have the right to free speech. But it has played out in a few cases that I thought were interesting and important to share. The first was the Bonds v. Bonds case, and in this case there was pictures of a child in a diaper eating tacos, and there was this quote, and there were really horrible curse words in here that I blocked out, but I, mother blank, love tacos, suck my blank. And it was the picture of the child eating a taco in a diaper. And the court used this information when making child custody decisions. And so it was found to be detrimental to his ability to raise the child later, and said that the person, but particularly the father, is indicative of an individual who has no business being in a position of authority over a minor. So while the parent wasn't required to take it down, it was something that weighed against the father in terms of his right to have custody of the child, or the amount, just like many other things can be used as a best interest standard to decide whether or not it is best for the child to be with this person. But it's not always that clear cut. In the Hardin v. Scarborough case, the court said that in the absence of conduct harmful to the children, a court cannot dictate what would normally be parental decisions about a child's health, education, or welfare. And in this case, the parents were disagreeing over what and how to share online, and the court said, as to social media, Scarborough and Hardin will just have to get along, not really making a judgment as to what can or cannot be said. In the Tinsley case, a mother sought an injunction based on an incident where the father, as a means of punishment, forced the minor child to post a picture of herself on Instagram holding a sign that said, "I will be a leader, not a liar." In addition, the father and the wife posted the same picture on their social media pages. The dad even made it his profile picture. The mom said it was inappropriate, humiliating, and demeaning, and she claimed that the father and his wife should be prohibited in the future from posting information about this. The court said that while, yes, we find what the father did to be not improper and inappropriate, and therefore the mom's request for an injunction to stop him from doing it was certainly not an attempt to control the father's parenting, and it was appropriate for the mother to seek the injunction. The court said that they were reluctant to interfere with a fit parent's constitutional right to parent and make decisions for their child as they see fit. Therefore, we cannot say that the trial court's ultimate conclusion that there was no irreparable injury, loss, or damage to occur to the child or to the mother was clearly wrong. Therefore, the trial court's decision to deny the request for a judgment, for an injunction, was affirmed. And so while the court said, yeah, it wasn't great that he did this, and yeah, she wasn't abusing her right to come to court and ask for an injunction, I'm not going to grant the injunction. You can't stop a father from parenting the way that they see fit. Some of the other laws that apply here, the United Nations Convention on the Rights of the Child is a document that we are the only member country in the United Nations that has not yet ratified the UNNCRC. We've signed it, we have not ratified it. So this is a document that in it has a number of rights for kids, and one of them specifically enumerates a child's right to privacy. And I think this is one of the reasons why other countries are further along than we are with regards to protecting a kid's digital footprint. That the right to privacy is stated there. We have signed the document, but we have not ratified it in our country. We see in cases like Bellotti v. Baird, which involved a child's access to abortion, that a child did have a right to privacy, and that the parent cannot access her right to abortion, even if the parent did not provide consent, because there was a judicial bypass mechanism, that the child could still get the abortion without the parent's consent by going to court, but did require that the child go to court in order to obtain that abortion. But it's another case where we see the court trying to figure out a way to balance the child's right to privacy with the parent's right to control the upbringing of kids. The court in the Bellotti case first held that it's the guiding role of parents in the upbringing of their children, and that would justify limiting freedom of minors. Courts, like parents, struggle to both protect children while simultaneously allowing them to grow into independent adults. So this controlling the upbringing of their children is something that we see regularly, and we see it in dependency cases too, on those borderline cases where we can't shelter, because parents do have many rights in our country, including the right to free speech. Even when courts recognize that children might have a reasonable expectation of privacy, the court often places a higher value on the interests of the parent and on the state in exercising control over the minor child. So what we do know is that courts are usually going to defer to parents. And I don't think case management agencies posting pictures of kids for adoption, or foster parents posting pictures of their kids, have been challenged very often in court. Who knows if they will or what they won't. But I don't necessarily think that the solution lies in legal measures as much as it does in more education. Who here thinks that the law should change, and some of the things that we've seen here today should be illegal or should be prohibited? Yeah? Why don't we go back here? Why do you think it should be prohibited, or how do you think? Who's willing to kind of elaborate a little bit on that? Are you willing to elaborate? You're fine.
Well, if you take it's an autonomy issue. So if you were to take autonomy away from anyone, that's not okay.
Yeah.
So when you say a child doesn't deserve the same autonomy as somebody else, we give them, in a lot of homes, their own rooms, doors that lock,
Yeah.
You know, they don't get to choose their schools, but they pick the sports they like, they pick whatever, and putting this on them doesn't allow them to lead a future life that they want.
It kind of takes away the ability for them to define themselves negative, positive, or not at all online when we share. A friend of mine told me an example of when she went to a party and she saw her niece and she knew like everything about her niece, and she was instantly able to go up to her niece and say, I heard you love to do this project, and I heard you went on this trip, and I heard you got straight A's on your report card, all these things that she read about online. And her niece was taken aback because she didn't know if she was supposed to embrace this person as someone she should be close with, or if it really was a stranger, because she actually had never met this person before. And so it kind of blurred the lines between safe people and unsafe people, because these strangers to her knew so much about her. Yeah.
I think that the information about someone when they're under the age of majority, I think it should trigger the right for that person when they do become of age to have some recourse about. I understand the question about screenshots and you can never take the information down, but I think that when the person becomes, when the person, because there comes a point when they have the full authority to decide what's going to be published about them. And I think that when they become of age, there should be a mechanism in place that they can go to a court and say, hey, all the stuff that Google has and other people posted, I want it taken down. I just think that that would balance it out and give them some sort of recourse as to what has been posted previously. And also, it should preclude companies that target them from using that information if they should do that.
Yeah. So I'm going to jump ahead because I think that your point is you set up, I don't know what you call it, like you set up the T so well for me to tell you what the answer is right now, so I won't hide the ball anymore. So my philosophy or my theory of one of the best ways we can handle this is by adopting something called the right to be forgotten, which is something that exists in Europe. In the European Union, there was recently a case that revived an old doctrine, a very old doctrine called the right to be forgotten. And the idea of the right to be forgotten was that when information is no longer relevant to a person's reputation or name, they have a right to have that information forgotten from the public view. And in Europe, the way that this played out was that there was a businessman who made a number of bad decisions in the 90s and in the 80s. But he set the record straight, he paid off his debts, and he was building his new company. And as he was building himself back up, he was struggling because anytime someone Googled his name on Google, or searched his name through the Google search algorithm, the articles about his prior business debts kept coming up to the surface. And so he sued Google, arguing that that information should be taken down. And what the court decided was that, yes, he was right. He had a right to be forgotten, and he had a right to have the link between his name and those newspaper articles broken and taken off of the Google search result feed. What the court didn't do is the court said that the newspaper still had a right to have that article in their archives. And so it almost struck a balance. It didn't delete the news, but it deleted the link between that person and that news story through the Google search algorithm and allowed him to kind of recreate himself. And so in the United States, it would be really nice if we were able to have some sort of a right to be forgotten, especially for kids. The reason why we don't have it right now is because unlike in Europe, where there is not a First Amendment right to free speech, they have speech rights, but they're not as broad as they are here. We have strong First Amendment free speech rights, and we have strong rights to allow people to have information to be out there and to be shared. And so it's a very big hurdle to overcome that in order for the right to be forgotten to exist here. But there was a law scholar named Amy Gaja who wrote an article that explored all the ways that we already have something like the right to be forgotten in the United States. We just call it other things. We call it delinquency law, where information that's, kids and criminal, that are charged with delinquent acts, that information is shielded and it's expunged at a certain point. We call it revenge porn laws, where images of people that are not supposed to be on the internet are required to be taken down. We have all these different ways that we have a right to be forgotten in other contexts, because when we try to walk the balance between privacy and speech, the importance of that privacy has outweighed the right to speech. And so there is certainly room for the right to be forgotten to perhaps come here. I might be a minority of people who think that. I might have to get all of your legal minds behind me if I march my way to the court to try to argue it, because I don't think I have a lot of buy-in yet. But I think that it's something that can certainly help. And we do see things like the right to be forgotten in states like California, where there are state statutes that say that when kids share about themselves, that kids have a right to delete the information that they post about themselves. That's already law in California. Not in other states, but there's some federal legislation moving in that direction, that kids should have a right to deletion, that kids self-reveal before they self-reflect. And because the juvenile brain is different than the adult brain, that self-revelation, they should have a right to delete it because of their neurological immaturity. So that's kind of where I'm going. So I agree with you. That was a long way of saying I agree with you. So there's a case that I think is really important to this discussion called the Citus case. It was in the 1920s. There was a boy named Citus was his last name. I don't know what his first name was, but we're going to call him Citus. And Citus was a prodigy. He was a brilliant kid. He had a really high IQ, and his parents kind of put him out on display in the 1910s, the 1920s, and he was in the New Yorker and all the different magazines as this bright child prodigy. And people were really interested in Citus. Citus grew up, though, and he didn't like the attention, and he wanted to live a private life. He wanted to be what the newspaper called a recluse, and he wanted to retreat from that public persona that he was placed in the spotlight as a child. Well, the New Yorker didn't like that so much, and they wanted to do one of those stories like, where is he now? What happened to this great child prodigy? And so they stalked him out like the paparazzi does, and got lots of pictures and ran a feature on Citus. And Citus was like, whoa, I'm a private guy. You can't treat me like I'm a public figure. I'm a private citizen. And he sued the New Yorker. Well, the court said, once a public figure, always a public figure. And the court held that the New Yorker had the right to treat him like a public figure because his parents put him in the limelight years before. The court said, I don't even know, or the court said, we don't even know if the child wanted to be in the public spotlight, but the mere fact that he was placed there as a child meant that he could not retreat from there as an adult, and the New Yorker had a right to stake him out. And so what this really makes me wonder is all the kids who become internet stars or whose parents post about them regularly or create YouTube channels, or maybe even the kids who are just really get a lot of attention as kids available for adoption, well, they have the right to that private life later on. We haven't seen how this might play out, and perhaps it's fear-mongering by saying it, but the case law has not caught up to this. And for people who were public figures in the 20s, like Citus was, those kids did not have a right to privacy as they became adults. So we've already kind of talked about the state intervening to protect kids from harm, and as a former CLS attorney and former child abuse prosecutor, I think I would laugh if a caseworker or a police officer came to me and thought I could prove that case in court. Not laugh at the situation, but laugh at the idea that I could meet the legal hurdle. I would feel bad about the situation, but I just don't think it would win. But it's something to think about. What are the margins? In what circumstances could the state intervene to protect kids from harm? What would a parent need to do? What would be extreme enough conduct for the state to be able to step in? And I'm not really sure what that is, but there has to be a line somewhere. We have to know what that line is so that we can stop people from crossing it. The other question I get asked a lot is, can a child sue a parent for oversharing? Or could a child sue a foster parent or a case management agency for oversharing? It's not really clear yet. I think when it comes to parents, the parental immunity doctrine would probably come into play, although that has been chipped away at quite a bit and it doesn't exist in all states. But it's certainly a possibility that we might see kids coming of age and wanting legal, to be able to assert some legal rights against their parents or other folks for oversharing. And then could a child sue a website to have the information taken down? And that's kind of back to the right to be forgotten piece. So, I went too fast. So this is kind of the right to be forgotten in an animated slideshow. I'm not really great at PowerPoint, that's why I went into law. But what this is actually, they didn't even teach PowerPoint when I was in school. So one of the reasons I think that Europe also deals with this differently than the United States is that information that's shared online in Europe is considered data, whereas information shared about people online in the United States is considered speech. When parents talk a lot, or foster parents talk a lot about the kids in their care as while the kids are little, the parent has a strong expressive interest. They might want to get help potty training. They might want to build their parenting communities. They might want to humble brag, or as you call it, what did you call it? Virtual signaling. And whether we agree with them doing it or not, they have an expressive interest then. At that point, it is parent speech. But as the kids get older, that expressive interest, that speech, kind of minimizes, and all that information that's backed up on my internet, that all stops being speech, and it's really just data. What I shared about my kids 4 years ago isn't speech, it's just data junking up my virtual cloud. And it needs to start to make way for the child's privacy interests. And perhaps as that shift takes place, we could see how the right to be forgotten could be relevant. Because in a way, it's saying, I'm not saying that what mom and dad were doing, going too fast there. What mom and dad are doing isn't important, or what the foster parent or the caseworker or the case management agency isn't doing is important, but I'm saying that that importance minimizes as kids get older, and the kids' right to control their digital footprint increases. So while the law could regulate at the margins, it's probably not the best way to protect kids online with regards to the here and now. The First Amendment hurdles are probably too high. And so instead, it's really helpful to think about changing public discourse. How many of you put your babies to sleep on their tummies when they were little? All right, so about half the room. How many put their babies to sleep on their backs? A few? Okay, anyone have kids that were born after like 2005? That put their babies to sleep on their tummies? Okay. Yeah, 2005. So what happened was, it used to be we put our babies to sleep on their tummies because that was the way babies fell asleep best, right? It was easier to get them to sleep very well. At a certain point, the American Academy of Pediatrics started to realize, or maybe not the American Academy of Pediatrics, but doctors generally started to realize that babies who were put on to sleep on their bellies were dying more frequently of SIDS. And so they started a campaign called the Back to Sleep campaign. And the idea of it was to educate parents that if you put your babies to sleep on their backs, they're more likely to not suffer from SIDS. It's not a fail-proof, but it's one step that you can take. You can take out the pillows in the bed. You can get rid of the bumpers, all those kinds of things. And so when parents started to learn a little bit more about the risks of putting their babies to sleep on their tummies, they self-corrected. They said, oh, I didn't know that. I'll sleep a little bit less. It's going to be a little harder to get my baby to go to sleep on their back, but I want to help my child, and so I'm willing to do it. And we didn't decide to legislate against putting your babies to sleep on their bellies. We decided to educate. And so in the same way of educating instead of legislating against something like the Back to Sleep campaign or the positions that we put babies in, I think that this is another place. Obviously, the risks are much smaller, and I don't mean to trivialize what the risks are with one or the other, but I'm saying that what we can do is we can learn from other examples of public health campaigns that were really effective at teaching parents to act differently in a way that better protects kids. And in the context of foster parents, I think that we even have a more well-tuned audience who is going to want to hear what we have to say and is going to want to adjust their behaviors to best help their kids to be able to succeed. We see it with discipline. Spanking, for example. 15, 20 years ago, a spanking was, oh, you spank? Oh, I don't spank. And it wasn't as big of a conversational piece because we didn't have the benefit of all the data that tells us how harmful and detrimental spanking is. We haven't outlawed spanking. There are limits to what corporal punishment can be done, but some corporal punishment is still perfectly well within a parent's right to do, but we see that parents have shifted their behaviors as a result of more education. And social media and parenting is a very new area. We don't have the benefit of a lot of research, but we need to start collecting it, and we need to ask the kids their opinions so that we can best educate them. So I say this quite a bit, especially, there's two things I say a lot to reporters when they talk to me about this. The first is I'm in no way trying to silence a parent's voice, because I think that there are good reasons that parents share, and it's a very personal decision, and my goal is not to stop parents from talking about their kids online. But the other thing I say is that adults don't intrude on a child's digital identity because they're trying to be malicious. They're often doing it because they haven't yet considered its importance. And our role is to try to show them how important it is. So Here's that quote I mentioned to you. NPR thought it was a good one, so when they tweeted out an article that they quoted me, and that was what they pulled from, that we're not trying to silence the voices, but that we have to recognize that kids might have an interest in entering adulthood free to create their own digital footprint. I'm a big believer in working outside my own lane, and so one of the people who I worked with a lot when I took pictures of sick kids at Shands was a pediatrician who also happened to be a friend of mine and someone who I had taken her newborn pictures when her baby was born. And we got into talking about this, and as a pediatrician, she felt that she had a role to play in stopping parents from oversharing and educating parents about the risks. And so we paired up and we were able to together present this research to the American Academy of Pediatrics 2 years ago. And we had a captive audience of about 2,000 pediatricians and nurse practitioners. And we advocated for perhaps adding this dialogue into well child checkups. So when you go to the pediatrician for the well child check and they talk to you about helmets and they talk to you about nutrition, that this is something else that they can talk to parents about so that it could be a public health model of educating parents. It's certain that in some cases the solution is going to need to be court action, but I think that in the majority of the cases this is something that can be handled more through education. And so these are the best practices that we've talked about, that we've come up with, and I think it's a good place to start. The judges that I spoke to on the family law bench suggested that these best practices could be these can be incorporated into parenting plans. They could perhaps even be incorporated into case plans or reunification case plans if social media sharing has been an issue in the past. And the reason why incorporating best practices for parenting into case plans, or whether it's in dependency or family law, is because once you actually have a set of guidelines that the parents agree that they are going to follow, you're more likely to be able to enforce a violation if it occurs. And so, for example, in a child custody case, if one parent tends to overshare and it bothers the other parent, that other parent isn't going to find a positive solution through a recourse through the court system. But if the parent had already agreed to not do certain things, then that parent could actually have some sort of a rule to show cause against the parent who violated the conditions of the parenting plan or the mediation agreement. So here are some of the best practices. The first is that parents need to familiarize themselves with the privacy policies on the sites in which they share. We should encourage our foster parents as well to know what the privacy policies are before they choose to share online. They need to know what the risks are. If they're sharing on Facebook, they need to know about the fact that Facebook has had privacy violations, that just because you're sharing with a small audience doesn't mean it will always stay small. There are glitches where the public has been able to get access to people's social media feeds. People who share about kids regularly, and perhaps case managers who have kids who seem to be shared on Facebook regularly or on other social media sites, or kids who are shared through different sites that promote kids for adoption, might want to set up notifications to alert them when the child's name appears in search engines. Every morning I get an email that tells me whether or not there was a Google alert or a TalkWalker alert where certain information that might have been shared about me, if my article was quoted, I will know because I will get an email in the morning. And we can do this for any kids that we think might have a regular presence online as well. Parents who are sharing about kids' struggles, foster parents who are sharing about kids' struggles, they should consider sharing about those things anonymously. There are ways that we could try to kind of limit the amount of information being shared, whether it's in a private Facebook group without the child's name, with an account that doesn't include our own name, different ways that we might be able to find a way to share anonymously. And if we do choose to share publicly, or if we do choose to share even semi-publicly about a minor's struggle, we really need to think about how that person would feel if they were of an age to be able to consent. I think that it's helpful to use caution before sharing a child's actual location or full name, that we can give older children veto power over their online disclosures. So kids should always, I think, have a right to be able to have information not shared about them. We should ask kids before we're sharing, and we should let their no mean no. We also don't want to post pictures of kids that show them in any state of undress, including cute bath pictures. That might be cute for grandma and grandpa, but it should not be shared online. And we should consider the effect that sharing can have on a child's current and future sense of self and well-being. So In conclusion, we need to seek a child-centered solution that balances a parent's right to share with a child's interest in adulthood, free to create their own digital footprint. Untangling a caregiver's right to share their story with a child's right to privacy is difficult. This is a brand new topic. The first kids to come of age on social media are only now starting to enter the job market, or only now starting to apply for college. There are so many benefits that we get from sharing online, whether we're caseworkers, case management agencies, or foster parents, and we should still continue to reap some of those benefits. So I'm not saying we need to stop, but we need to shift societal discourse so that we start to think about this as an important issue, not as a silly issue, not as a word, sharenting, that is kind of a weird word to use and sounds like sharding. We need to think about this seriously. So your voice is really needed in this important discussion, and I hope that you found what I had to share with you, we wanted to present to you, to be relevant to your work and stimulating to your minds. So I welcome questions.
I think there's one other flip side that we're now starting to run into, and
Uh-huh.
that is kids, as they're getting older, are the ones that have been adopted are then finding their biological parents, or the ones that are still in care, because they're so quick. I mean, all they got to do is Google or go into Facebook. So it's also then again educating that caregiver as to, because they're going to do it,
Yeah.
what they're going to find. Because I know we had these two kids and they were on it like nothing. And mom was still a stripper, abandoned them, all that kind of stuff. And had their baby pictures. And they'd never seen their baby pictures. I mean, there was so much to it. I didn't even really know, none of us really knew how to do it. Because they had nothing with them as far as baby pictures as infants. But it was posted on a very open Facebook. And then mom's still doing mom checking and all that kind of stuff. And she found it. We knew it was a matter of time, but it was a matter of how do we maneuver ourselves through that.
What a great point. Yeah. I mean, you even think about, one of the things that I've said a few times while I've been going through this is Facebook is the modern day baby book, right? And so we have kids who come into care at a certain age, and they have a Facebook that trails them since they were in the womb. Do kids have a right to that information? Should part of what we do as we transition a child to adoption is gather those pictures for them so that they have it?
That's what we did first, but then as she got older, she was able to, because mom's Facebook was still mom's Facebook.
Well, it's great that you even did it to begin with.
We did it with two different cases.
Yeah.
Because if it's open, you can collect all that stuff, and it's nice for them to have. So.
Who owns the rights to those pictures? That's a great point, too. Yeah, sure. Yeah. That's a great point. I hadn't thought of that. Thank you. Yes.
I belong to a nonprofit that takes kids out, high-risk kids out of church. Then we have a Facebook page and we put their pictures on there. Now, are those kids traceable? We don't put their names or
Well, it's hard to say. I can say that in the future, I think it will definitely be traceable because we have such facial recognition software. I mean, who's ever uploaded a picture and it asks you if you want to tag people? The computer knows who that person is. And so really that information is out there. The fact that the child was in a high-risk program or was at risk or went to that, I think that while right now it might not be a tangible concern, I think in the future it absolutely will. And in the book that I'm writing, I explore how, whether it's a nonprofit group or a site like Class Dojo, which collects information about kids in public schools and sends parents alerts when their kids misbehave. All of this is contributing to a child's digital dossier that could be marketable in the future and could kind of categorize kids as kids that are successful, kids that are athletic, kids that are high risk. And how can that be used? How could that be monetized? How could that be used to harm kids in the future? Unfortunately, we're only beginning to see how it can be done. An unrelated but slightly related study that I saw was most of the work that I found was done by scholars at universities, but there was one study that I stumbled across that was done by Microsoft researchers. And what they did is they tracked new moms' Twitter feeds, and they were able to identify with 81% accuracy which of those new moms were at risk of some sort of a major postpartum event of depression or some sort of major event from their postpartum because they were so acting on Twitter in a certain way. And what the researchers said and what I said is, well, first what the researcher said was, this is a great public health tool that we can use to identify high-risk moms, right? But what they said later on in the article, and what I said when I first pulled it up, is, did these moms know that there was artificial intelligence slowly collecting their data and being used to categorize them as someone at risk of postpartum depression? And how does that factor in with what we share about our kids online also? Are we setting kids up for, well, based on those, these pictures that we've seen or these places that the child has been, that they're more at risk of a health event or they're more at risk of a behavioral event later on? I think they did, yep. And in that case, and I'm not my expertise is like this, and this topic is like this, but my gut would tell me is the difference in that and this postpartum mom thing is that Facebook took the result and they modified, exactly. But it doesn't mean either are right. And what the Microsoft folks said is what we're doing is nothing new. It's the same thing as targeted advertising. If you're posting lots of pictures of babies, we're going to advertise pictures of, things with kids. So, yeah.
So I hear you're advocating for more education, especially for foster parents, but would you also advocate that we codify some law in Florida, or at least minimum guidelines to protect our kids and stay care? There's frequency of photographs, what type of photographs, at least there's a baseline that foster parents can't legally drop below.
So that's a great question. I'm in a difficult position because of my job. My role is a university professor. And so when I do things in the course and scope of my employment, I have to be really careful that I'm not lobbying. That doesn't mean that I can't be called as an expert by a legislative body or by a court to give my expert opinion on it. But what I found quickly in the context of that morph child pornography issue, where I was like, oh my God, how is this, other states have updated their law, why haven't we? That it was not within my, I don't want to say rights, or it was not something that I was supposed to do. I couldn't send my paper to Congress and say, hey, look at this, or the Florida House of Representatives, look at this and change your law. I can certainly be called as an expert for things like this, but I have to be really careful to not be a lobbyist. And so I don't disagree with you. It's just, that's one place that I have to stay in my lane, I guess. But you can pick up the issue for sure. I'll give you my card if you need an expert.
Yeah. The daycare live feed, and any event where you're signing a waiver, can the kid sign that waiver now if they're of age, or is it the kid entering into a contract and now they can't? I mean, how do these waivers go with your photograph being taken and put out there?
I think that there should be. Right now I don't think there are any ways the kids can't contract and they don't sign these waivers. Who signs the waivers for kids that are in care? Who signs and at what point is it important enough that the child should have, some sort of informed consent? Does that mean there's an attorney who talks to the child, or does that mean, other people can help someone give informed consent? Does that mean their volunteer guardian ad litem should talk to them about it? Kids assent to medication all the time. I mean, there's a box that the doctors check before we give them psychotropic medication. So I think those are great points, and we don't have guidelines yet for it. That's a good point, though. Other thoughts? I didn't include it. Oh, you can see me a little bit there. My email address is up there. My Twitter handle is right there. I'm really happy that Jessica and I got to talk to you today. If you want to chat with me afterwards, feel free to come up and say hello.